Disclaimer. The information and answers contained in this webinar provides a general guide to certain laws that apply to medical spas. The information in this webinar is for general reference only, and accuracy cannot be guaranteed as medical spa legalities and regulations vary by state and change very frequently. This information is not intended to provide legal advice, and it should not be relied upon as legal advice. This information is not intended to create, and receipt of it does not constitute an attorney-client relationship. Viewers should not act upon this information without seeking knowledgeable legal counsel that takes the laws of your jurisdiction into account. All the uses of the content of this webinar, other than personal uses, are prohibited. Thank you. Today's speakers are Bradadato and Bala Mohan. Bradadato, JD, is a partner at Bradadato, a business, healthcare, and aesthetic law firm that practices across the country. He has worked with physicians, physician groups, and other medical service providers in developing ambulatory surgical centers, in-office and freestanding ancillary service facilities, and other medical joint ventures. He regularly counsels clients with respect to federal and state healthcare regulations that impact investments, transactions, and contract terms, including Medicare fraud and abuse, antitrust, anti-kickback, anti-referral, and private securities laws. Bala Mohan has a unique background in healthcare law because of her extensive experience with intellectual property law. She is a registered patent attorney eligible to represent patent and trademark applicants before the United States Patent and Trademark Office, USPTO. She has an extensive experience counseling and assisting clients with trademark applications and prosecution processes, specifically trademark clearance searches, filing trademark applications, and responding to office actions. Bala also focuses on understanding and resolving regulatory and legal issues governing the medical spa industry. And with that, I'm going to let you guys take it away. Thank you.
Hello. Good afternoon, or good morning, or I guess good evening, depending on what time zone you're in, or actually what time you're actually listening to this webinar. We're excited to be here speaking with you all today. And as you can notice, the title's pretty long here, and so before it gets all caught up in your mouth, you probably ask the question is, why should I be listening to this webinar, and why do I really care? And, that's a pretty valid question. The aesthetic market has become an attractive option for so many entrepreneurs and other physicians with either little to no background in the aesthetic space. We have owners now that come from different perspectives, or marketers that are coming from big box retail stores with no medical background whatsoever, and they're bringing all of that, their concepts of how they market to this, which then drives a lot of the questions as to how do I then advertise correctly. And so the first thing that we're going to have to ask everyone here to agree with us on is that when you're rendering med spa services, you're rendering medical services, and that is within the practice of medicine. And if you disagree with that statement, probably this is the point where you can hang up and not be a part of this call, because the rest of it is really going to be discussing how marketing and medical marketing, how different it can be and how important it is to understand the difference. And we can all at least agree that marketing is important. It helps drive business. It helps drive, obviously in a med spa business, ways to attract new patients. And so as those who are listening, as owners or operators or medical directors with your med spa, you are subject to a bunch of different medical advertising rules. And today what we're hoping to accomplish is give you some tools to think about before you go start your marketing initiative, so that you can be compliant. Because why do I care? Because you care because you don't want the med spa police kicking down your door asking for your papers. Of course, those of you know better, there is no such thing as med spa police. The federal government, federal agencies aren't going around kicking down doors, and they're not asking you for compliance and confirming that your marketing material is up to date. And the reason is they don't really need a SWAT team. They don't have to have a police force to kick down the doors, because there are a lot of hotlines out there for people to call in. And who are those people, Bala?
Sure, great question. So, typically the federal and state agencies responsible for regulating medical practices and medical spas, they don't go actively looking for non-compliant ads. From our experience, we can definitely tell you that these complaints are usually reported to these agencies from one of these following 4 categories of people. One, an unhappy patient, 2, disgruntled employee, or even a jealous competitor. And the fourth and the final, Brad.
And this one's our favorite just because it's so much fun to listen to, is ex-spouses who are mad. And yes, they will report you if they can. So yes, angry people typically are the ones that are going to be driving this. So a lot of times when you're little, you're worried about, the monster in the closet. And in this case, for when you're running a med spa, you're not familiar with medical advertising, you're worried about the unknowns, or in this case, again, the monster in the closet. Well, as you grow up, you learn there aren't monsters in the closets, but for you guys, what you need to understand is who these regulators are and what are the marketing aspects that are out there and what efforts are you going to use. And what we're going to do is kind of give you some of that information up front. And so the regulators that we deal with on a day-to-day basis, or will be the ones in which that will be overseeing your advertising, is twofold. One, the federal side, which will have the FTC, and second is the state level, and that's being broken up into different versions. But let's just start with the federal regulations, because the one thing that's important to understand is for federal regulations, it doesn't matter what your state does, you will have to comply with federal regulations no matter what state you're in. And Bala, let's talk about the FTC.
Sure. So the FTC is the federal agency that governs medical advertising, and they get their authority to regulate under this act called the Federal Trade Commission Act. And under this act, basically, advertising is legal so long as it's not false, it's not misleading, or it's not deceptive.
And so let's talk about, the words false, misleading, deceptive. I think the next piece would be really understanding some good examples of what we've seen, either from publications or other actions by the government.
Yeah, sure. So I think the example here would be the best way to process what each of those requirements mean. So let's look at an example here. So the question here would be, once you read the example, is the ad making a false claim of a material fact in either an explicit or an implicit manner? Now, before we go ahead and answer the question, you may be wondering, what does material mean here? Good question. So if the information in the ad would affect, a consumer's decision on whether or not they should sign up for the medical service that your spa provides or buy a medical product, then the information is considered material. So what do you think the answer here is? It's definitely a yes, without a doubt. We all know that no two patients are similar because they differ in their medical history, their age, their skin elasticity, and but there are various other factors that play a role. And achieving the same outcome for every patient is almost next to impossible. So clearly here it is a false claim that all patients will experience a specified improvement. Now let's look at another example. So the non-compliance piece here in this example is that the ad implies that liposuction is a minor procedure with low risk of any serious adverse complications, that it's absent of significant discomfort or a lengthy healing period, all of which are contrary to the actual facts. So here the ad misrepresents, one, the risk of adverse complications, the typical recovery time associated with liposuction, and these are all material facts because had a patient known this information, they may have opted out of it either because they can't get enough time off of work or because they just don't want to take the risk of any complications. So the FTC prohibits such misrepresentations so that a consumer or patient can make an informed decision before they sign up for such a procedure. Now let's look at another example. Lose the weight with an X procedure and keep it off. Now whether this ad is used in relation to a weight loss procedure or a weight loss pill, one's radar should immediately go up the moment you see it, because such an ad is at high risk of being flagged by the FTC because it omits a very important fact. And you may have already guessed the answer. It basically fails to disclose that in order for one to keep off the weight, you also have to maintain it with a complementary diet and exercise regime. So in essence, the bottom line here, what we're trying to get at is that you should be able to validate any claim that you make in the ad, or if you're going to leave out some information, you should be able to prove that a reasonable patient would not want to know in deciding whether they should go ahead and come in for a procedure. Now, I want to bring your attention to health claims specifically. So please be extremely cautious when making health claims in your ads, because the FTC is usually the least forgiving for health claims, especially the ones that are false or even ones that are unsupported health claims. And they impose a much, much higher standard. So while ads require a reasonable basis for their claims, health claims must, and I want to stress on the must here, be supported by competent and reliable scientific evidence. Now, please also note that, an expert or a celebrity endorsement will not constitute as competent scientific evidence. So if you cannot prove the health claim with support, just don't make it, because it's not worth any short-term gain that may result from it, as it's usually only a matter of time before it gets onto the FCC's radar and you being subject to any of their prosecution.
And after all those awesome examples follow, they might be still saying, yeah, but why do I care if I do something like that? It's just the FCC. What can they do?
Great question. Yes, you must care, as you can get hit with massive federal civil penalties. And, the penalties imposed by the FTC will usually depend on the nature of violation. One of them could be a cease and desist order. And you're right in thinking that these are legally binding orders that will pretty much require a medical practice to stop running the ad immediately. While this can be a slap on the wrist, it can also be a major penalty if the medical spa, if the medical service that the spa is offering is central to its business and all the sales must suddenly cease. And another one, the civil penalties, and we can't take it lightly here because they range anywhere from thousands to millions of dollars, depending upon the nature of your violation. And take note here, million-dollar penalties are not uncommon. Yes, you're seeing the numbers absolutely correctly. The FTC enforcement actions just yielded in more than $2.3 billion with a B. Just between July 2017 and June 2018, just within a year. So you can see that the FTC takes their authority very seriously that's vested in them.
And so this is not just a topic in which the FTC is aware of. In fact, we wanted to just kind of bring the attention to some hot items that the FTC has just in 2019. They have actually gone after IV therapy clinics. They've gone up to CBD product places and weight loss systems. All of these have the same kind of concept, is that they've made healthcare claims that they lack support. And Bala was just talking about that, and this is what that we know the FTC is in high alert. So when it comes to healthcare claims, do not, and I'm going to say it one more time, do not make them unless you can fully support it with competent, reliable, and scientific evidence. If you cannot, when you get that cease and desist letter and you cannot prove it, then you are opening yourself up to penalties and other issues. All right, well, now we know who these federal monsters are. Let's get to know our state monsters. And the state monster, unfortunately, is a little bit different, because a state monster is more like a three-headed monster. You're not exactly sure which direction it could be coming from, because you have different bodies that are out there that can enforce state regulations, including our attorney generals of the state, or your medical board, or your nursing board, or other types of boards that are out there. So let's just start with the very first one, which is the Attorney General. Now, the Attorney General's office, they are the grand poobah of the state, of every single state, in the sense of their job is to enforce state laws. And as you can imagine, in every single state, there's a host of healthcare laws that are out there, mostly having to do with compliance and other things, but also there may be some certain laws as it relates to protecting the consumers and or how you market. Most of these state laws all kind of follow similar to the FCC, what has to do with false, misleading, or being deceptive of some provisions. And then we'll talk a little bit more in detail, but depending on the infraction, similar to the FTC, you could be receiving some type of consumer complaint or a cease and desist order or a temporary restraining order, all which then lead to other type of triggers where it can have violations. But the one trigger that it can do is then trigger something with your boards. And we obviously want to avoid that, because that then triggers how you can be continued to have your professional licenses. And then advertising in general, we're going to take a kind of a big picture look first. And when we talk about medical advertising, a lot of the state boards and state governments have looked to the AMA for at least some guidance as to how to develop their advertisement rules. And so from a big picture perspective, the first thing to understand is the American Medical Association has no power over you and your states, but it does give them influences, and the AMA has been cited in multiple opinions by your attorney generals or from your state governance as to using it as guidance, and or your medical and nursing boards as to use of guidance. So we do give it some credence, even if you're not exactly, it does not control you. So the first thing is obviously don't make any guarantees of success or statements which play upon the vanity or fear of the public. Don't create unjustified expectations about what those results of a procedure are. And don't use models and actors unless you're disclosing the fact they're using models and actors. And we're going to get into certain states where that becomes very clear. And then finally, any ad that creates a false, misleading, or deceptive, again, similar to our FCC rules, can create that trigger to cause that professional misconduct, which obviously in the worst case scenario can lead to certain tragic results for your ability to practice in this field. Since we're sitting in Texas at this very moment, I thought we could start with a state that we are very familiar with, but like the federal rules, most states will have some version of the false, misleading, or deceptive aspects when it comes to advertising. But you need to pay particular attention to your state laws and how, from a healthcare perspective, how you can advertise and what restrictions you can and cannot do. But in Texas, the Texas Medical Board has been kind enough to give us about 4 pages worth of regulations for physicians on how they can advertise. And, you know, obviously we're not going to go through all 4 pages, but for starters, if you're a med spa and you're having an ad, you can't, and if you have a fee, you can't say it's free and it's not. So free has to mean free indeed. And likewise, a medical spa ad must never contain any untruthful or deceptive claims regarding what those costs and fees, regarding costs and fees. Further, Texas law prohibits physicians from advertising in a manner that causes confusion or misunderstanding regarding your credentials, your education, or your license. So this means that a physician must accurately advertise their names or their assumed names without causing any confusion as to the doctors or the med spa or the practice. So for instance, if you are a physician that's recognized as a board certified, you can obviously use that. And then if you are a physician that has been recognized by a particular trade magazine that says you're one of the best doctors at this particular procedure, you're obviously able to use that. You can't just start giving yourself awards and saying that you are the best doctor in the state of Texas at this service unless somebody else who's a third party has recognized you for that, and you actually have to cite to that. So I'm going to give you an example. This particular case, we had a client of ours who was working with a third party. This language is almost verbatim off the website, basically saying that this group was really good at it, and no one's better in the whole United States, basically, to render these types of services. A competitor ended up filing a complaint with the Texas Medical Board, alleging that this was, and then the Medical Board came back and said, yes, we believe this advertisement is deceptive, false, and misleading, violating the Medical Board rules. And even though a third-party vendor had created, in this particular case, our client had no idea, their answer was, it does not matter. You, the physician, is ultimately responsible for ensuring that any information that's made about you and or your practice has to be compliant no matter who the third party is. And so what I always recommend, this goes back to when we first started our conversation, is there are a lot of marketers coming into this world that come from the advertisement world where medical rules don't apply. And so what they're used to using when they're advertising cannot be used the same. So the same fluffy language that you would use in your other type of skin cream products that are not prescription-based, or in clothing or other lines that people are coming from, you can't use that same language. So when you are working with third-party marketers or internally with your own marketing team, be very aware of how easy it is to step over that line. Another example that we have of how easy it is to violate the cause confusion as to your education is understanding how to keep your websites and social media up to date and updating it timely. And as you can imagine, websites and social media is a form of advertisement when you're promoting yourself. In the particular experience that I'm about, this particular client was a nurse practitioner, was credentialed as a nurse practitioner, but had let her NP lapse and had failed to update her scrubs and update her social media website that she no longer was a nurse practitioner. They had an employee that was terminated. That employee notified the nursing board that, oh, by the way, this particular person is holding themselves out as a nurse practitioner. Go to their website and you can see it. And sure enough, when the nursing board saw it, they did see that she was still holding herself out as an NP. Luckily for this particular person, she was not acting as an NP. She was only doing the duties as an RN. And even though she had on her scrubs NP and on the website still reflected the fact that she was an NP, she was not acting as an NP. We were able to update her scrubs and her website, noting the fact that she no longer was an NP, and the nursing board dismissed it, much to the chagrin of the former employee. But the point is, it's very easy to fall outside the scope, and just be careful as to what you have on your social media and website as it relates to your expertise. Another state, California, is similar. It also has advertising rules, and very similar. You can't be misleading, factually inaccurate, deceptive, or you can't use unsubstantiated claims. Additionally, any use of photos or images, if you're using a model, you have to clearly identify that the person is a model and that that person is not an actual patient and had not undergone any procedures by that particular provider or at that facility. And if you probably go to most websites, you probably don't see that, and that's how easy it is to violate the California laws. In addition, if you're using before and after pictures of your actual patients, which obviously we would, if you are using it, you should use your actual patients, you have to use the same angle, the same lighting for the before and after pictures. You can't clean it up. So you can't have a super dark room for the before picture and it's all cleanly and clean. For the after, they have to be apples to apples, so keep that in mind. And at this point, you're probably still saying, yeah, but why do I care?
Good question. So, because the state enforcement actions can prove to be pretty costly, just as the FTC's enforcement actions, you want to make sure that you abide by the state laws as well. And some of the state's sanctions can include the state attorney general's bringing a lawsuit resulting in real hefty fines, or depending on your professional background, it could be the medical board or the nursing board that can bring a disciplinary action against your medical license or your nursing license. That can include anywhere from a probation, a suspension of your license, and real egregious cases may even lead to the license being revoked. So in essence, we just want to avoid dealing with any of this.
And so, from a medical advertising perspective, as you heard, we've kind of hit those over and over again, but that's just a piece of medical advertising, and one piece that a lot of your marketers and yourselves will often ask about is, and Bala was kind of alluding to some of it, is endorsements and testimonials. And we get to ask this a lot. Bala, are endorsements and testimonial, are they ads?
Yes.
Oh. Well, if they are they subject to the same regulations by the FCC and state laws?
Yes, and yes, they're subject to the FTC regulations and the state laws. And not everyone realizes it, as you just mentioned, that endorsements and testimonials are also considered ads, and they're subject to FTC and state regulations. And for all of y'all out there, the FTC did update its guidelines of endorsements and testimonials in 2009, just to include all the current marketing techniques with Instagram and Twitter and all that's out there. I'm not going to get into the guidelines, but the fundamental principle here is that the endorsements and the testimonials need to be honest, truthful, and not misleading.
Right, and if you go to ANSPA's website, you will note there is an entire thing on influencers as a webinar that somebody on this call has already done. So if you want to learn more about that area of how to, if you are using endorsements and the restrictions, definitely go look at the ANSPA webinars.
That's right. Okay, and some other notes that I want to give you in terms of endorsements and testimonials. Anytime you're making a disclosure or a disclaimer, follow the 4 Ps that's listed here. And even according to the FTC, disclosure, they will consider it to be effective if you just follow the 4 Ps. As you can see it, proximity, what I mean by this is if you're making a disclosure, try and put it just as close as possible to the claim to which that disclosure relates to. In terms of presenting the disclosure or the disclaimer, word it in a way that will be easy for a patient or consumer to understand. And if you're going to put it in color, make sure you pick a shade that will stand out against the background and not get drowned in it. Again, prominence. Make sure that you're putting it down in a font that's easy to read, and especially if it's an audio, that it's read at a pace that one can understand and follow. And finally, when it comes to placing them, this is important. You want to make sure that the consumers are able to see it. So avoid distracting factors, especially if it's an ad in a TV or a video on YouTube. Disclosures should not be set against moving backgrounds. Instead, you place it on a screen long enough so that anyone who's reading it, will be able to notice it, clearly read it, and also be able to understand and process the information. The basic gist of it is one should be able to easily find it and understand what the disclosure says and means.
And then those of you who are interested in using testimonials, this is really state-driven. It's constantly evolving as to how the states view testimonials, and we'll kind of jump into a few of them. I know for New York, they believe it's against public interest to have testimonials. Texas is actually pretty controversial, although it's allowed. Similar to the you can't include false, deceptive, or misleading statements. There's a whole bevy of explanations in Texas. We do have clients in Texas that do use it, and they're very conscious of that. I actually know of a person who serves on the Texas Medical Board that uses testimonials and feels comfortable about the restrictions. So again, just be aware that you have to be very careful. California, very similar as to using testimonials are allowed, but just like Texas, you have to be conscious of not misleading or deceiving or failing to disclose certain material facts. And which leads us back to our AMA, which is where we started when we started about medical advertising. The AMA does have issues under the Code of Medical Ethics and warns that using testimonials for patients can lead to certain professional misconduct. The AMA, believes that all claims need to be objective with respect to the experience, the competency, and the quality of the medical services. It must be only if they can be only be used if they can be factually supported. So keep that in mind that if you are interested in using testimonials, which a lot of your marketers will want you to, and we get this question all the time, if you are going to do it, make sure you understand those restrictions in the state. The other questions we often get is, well, what if someone's putting a testimonial on another website? And so long as you're not citing to that website and bringing it on, the medical boards have been pretty consistent that you have no control if they go to another review site and say all these wonderful things about you because it's you didn't post it and or you're not controlling that website. But if you then bring those onto your website, and as a linkage, then they say you're now endorsing that testimonial, and so you are exposing yourself. So just be mindful of testimonials can be used, but it's an area you have to walk very carefully through. So key takeaways about dealing with the unknown. So now hopefully you actually know that there are no monsters in the closets. And so let's, obviously advertising, we've kind of hit you all over the head multiple times by talking about being false, deceptive, misleading. That's just because that pretty much summarizes how the AMA looks at the FTC, the vast majority of the states. And how do we do that? Well, when we do advertise, we want to say use information that's objective. Obviously, don't use material facts. If you are going to have some description, obviously rely on scientific evidence, because in cases where the boards come along, the FTC, if you don't have any information to back up your statement, they're going to hold that against you. And then don't play on someone's ability to believe that they're going to have certain expectations by having this particular procedure. Your skin's going to glow all the time. It's going to be so beautiful that every man that sees you wants to marry you. Again, all the fluffy words sound great when you're writing them, but in the medical world, they just don't work.
Right, and then next, again, with disclosures and disclaimers, just remember the 4 Ps, and make sure, especially things like if you're paying someone to endorse your service or your product, or if they're a relative of yours, or if it's an employee of your practice that's endorsing your service, or a certain practitioner at your practice, you want to make sure that you're disclosing and disclaiming it, because this is something, if you put yourself in a patient's shoes, that they would want to know, just so that they can make an informed decision and make an unbiased opinion too. So again, 4 Ps. Make sure, think about the proximity, the presentation, the prominence, and where you're placing it. The bottom line being it has to be clear and conspicuous so that a consumer can easily notice it, read it, and understand it.
And finally, testimonials. As we mentioned, you need to be very conscious as to how testimonials are viewed in your particular state, because some states either frown upon them or just outright say you can't use them. And again, this is constantly evolving. And then if you have testimonials, they have to be factually supported in some capacity. I know it's another person who's saying it, but if it's on your website, you have to monitor how those testimonials look and feel. And then finally, if there are some type of endorsements that are being used via your testimonial, make sure you have, again, as Bala was almost bringing the 4 Ps into it, or if there's some type of endorsements that kind of chase it with your testimonials, you can't rely on those as scientific evidence that some celebrity has endorsed it or has some testimonial on it. But those are the big key takeaways. If you have any questions, I know that we can open up now to take those on, or through AmSpa, you have the ability to reach out to the team and submit your questions.
Thanks, Brad. We've already got one, and it is, what would I search for if I needed to know the exact laws on testimonials in my state? And then they put West Virginia.
So unfortunately, where they maintain that, it's going to be different areas. So it could be a statutory in West Virginia where it has under the consumer protection laws. It could be also, depending on your type of position, your medical board also has certain rules and regulations as to what you can and cannot do. And then if you're a nurse, your nursing boards have certain things on the restrictions. So those are the 3 areas that it could be located in that state. No. And I just don't know West Virginia off the top of my head, so apologize that I don't know off the top of my head.
Okay, and we'll wait for more questions, see if we have any that come up.
And obviously, we threw a lot of information at you, and as you're digesting, you're planning to rewatch this. As a reminder, as a member of AmSpa, you do get a consult where we waive our consult fee. And if you have questions on this or other matters, you can set that up through ANSPA on having a consult with one of my members of the Bernardino team.
Okay, I'm not seeing any additional questions. Oh, actually, here's one. If I wanted to use images on our website of models, do I still need to disclose, or does this only apply to ads?
So yeah, anytime you're using an individual as it relates to the perception that that individual had work performed at your facility, you wouldn't want to note that those persons are models. I guess if it's clear to the outside public that there's just a person sitting in a waiting room or other type of image that it doesn't look like it's something that the physician would have performed, I don't think that would be confusing to the outside world. You just put your regulator hat on when you are doing that as to, could this be confusing to the outside world that this model is someone who I would have performed services on, or is just a stock photo or stock image that I'm using for this particular page that has nothing to do with the actual procedures that I would be performing. So I think that's the hat you have to wear when you're deciding whether or not you need to disclose it.
Okay, and there's another question about testimonials. Would before and after photos be obvious enough not to require that disclosure?
If before and after pictures are not considered testimonials because they're a photo and they're not a description. And so if the question is there anything that I have not seen a state that prohibits before and after pictures and have not viewed that as testimonials. In fact, if depending on what your background is, a lot of medical, you have to have before and after pictures to kind of demonstrate, you don't have to. If you're board certified, having before and after pictures is very important, depending on your background, but I've never seen anything where it equates testimonials and before and after pictures as the same. So I'm not sure if that's what the question is. I don't know if that person could specify a little bit more on that one.
Oh, I apologize. It was two questions right next to each other, and they were not sent by the same person. So I don't think that was actually about testimonials.
Okay. What's the two questions then?
Okay, clarification. Would using before and after photos in advertising purposes require the model disclosure?
Yes.
And only one other thing that I wanted to add is, again, it goes back to creating realistic expectations, justified expectations. Like if a patient were to see it, would it mislead them thinking that, just by doing this one procedure, I'm going to end up looking like the person in the picture. So it all goes back to creating expectations and making sure that they're valid. And if you are pulled up by a board just because someone snitches on you, can you support that statement or that picture or whatever claim it is that you're making?
100% agree.
Okay, this is about testimonials. The owner of our business has told me that we can't edit for grammar. Is that true?
Yes, that is true. You want to, whatever the patient has said, you want to keep it the way it is written, even though it does not reflect probably the person's anger of lack of commas or periods or capitalizations or typos. So if, that you can't control, but you want to be, anytime you start manipulating the verbiage used by the patient, the question starts becoming, what else did you manipulate? So we definitely tell our clientele to not to let the patient use their own words, whether or not it's grammatically correct or not.
So when you're not editing for grammar, that includes no commas or periods, just to be clear.
Correct.
Okay.
And the point on that is, the moment you start manipulating their words, it brings in the question, what else did you do? And I know it sounds silly, but you want to be, anytime if you ever got audited, you can show that you've never touched the corpus of what they've said. And it actually, believe it or not, I think shows that if there are certain things too well written, they start wondering who's writing it. Because everyone's going to have different educational backgrounds and speak differently as far as their tone and their voice. Let them speak in their own voice, even if their voice is grammatically incorrect.
And here's another question. Many models and actors post personal pictures/videos on devices we have in our office. Is it legal to repost these as long as we don't claim them as our own?
Yeah, you would just have a disclaimer noting the fact that this model is endorsing you and using that, and it's not that maybe they have had procedures on your facility, but yeah, you're allowed to use those if obviously with the proper permissions and proper disclosures.
We had our ability to boost posts taken away by Facebook and have not been given a reason why. What can we legally do?
I would contact, there's a group out there called Medical Justice. One of my partners, Jeff Siegel, who's an MD-JD, helps run that. He has a really good understanding of how to deal with Facebook, Yelp, and other sites. That is an area that we, as a firm, don't have a strong understanding, but that's one of the reasons why we partner with Medical Justice. So definitely, it's Jeff Siegel with Medical Justice. That is his expertise.